somebody was a silencer or a magazine, potentially it can end up with the same sentence as somebody with an AK-47 and an M16. It's a question for the society whether you think that that approach is proportional or we have to apply the law as it is. Once you have a mandatory minimum, then you have a floor below which you cannot go. And these questions have been raised in Trinidad, the Republic of Trinidad and Tobago. And I think the Court of Appeal there actually found a mandatory minimum to be unconstitutional. The argument is that it does not allow in the sentencing process the circumstances of the particular individual to be taken into account sufficiently. So that was the problem that the Privy Council had with the death penalty. For example, so we have a mandatory death penalty. A homicide can take place in an infinite variety of circumstances. So similar argument may arise. And so what it is saying then, and this is a question not just for judges, but for people, generally, members of the public. So you, and many of us don't seem to appreciate how easy it is to become ensnared in the law, with criminal law. So for example, youngsters go out on a Saturday night. One has a bag, and he says to his friend, hold on to this for me. And just as you take the bag, the police arrive. Did you have the bag? Yes. You are going to go to the court to say to the judge, boy, I don't really know what is inside there. He just gave it to me, and that friend can't be found. Now, think you go before the judge, and the judge will be saying, I've heard this story so many times before. What do you think the judge is going to do? Think about it. So that may be an 18-year-old, a 19-year-old. So where we are now is with somebody who was a silencer or a magazine, potentially it can end up with the same sentence as somebody with an AK-47 and an M16. It's a question for the society whether you think that that approach is proportional or we have to apply the law as it is until somebody makes a constitutional challenge, and then you see how it pans out. But those are a question not just for judges, but for all of us.
Last month, the Justice Minister proposed an increase. He brought 2 bills to Parliament proposing increases to the mandatory minimum sentences. Defense attorneys and the opposition raised concerns that this might cause the backlog in the court system to balloon. Are there any concerns on the part of the judiciary in this regard?
There would be a concern because, again, human beings respond according to the incentives presented to them. If moral arguments had worked all the time, as I said, crime would be no more. Religion has been around ever since human beings appeared on the face of the earth. And all the religions preach good living, righteous living, don't do certain things. If those things worked, then we wouldn't have need for lawyers and judges. But we are where we are. So if I'm a rational person, and I am 21 years old, and I am charged with the police for illegal possession of firearm, when I speak to my attorney says, well, young man, if you plead guilty, it's 15 years. If you go to trial and the judge is benevolent, you still end up with a minimum of 15 years. If you don't go through a trial, you don't increase the possibility of an acquittal. But if you go through a trial, you increase that possibility. So, as a rational person, what decision would I make at 21 years old? So that is it. And so now, we anticipate that the gains that we have made in terms of clearance rate and so on, I expect to see reverses in that, especially with the rural circuits. When we spoke about the rural circuits, they sit 9 weeks for the year or 12 weeks for the year. So it means that any matter that isn't done, say in this term, is going to go down to sometime around June and July. Next time after that is November, December. So what are the things that can happen in the meantime? Witnesses, unfortunately, may pass on. Witnesses may migrate. The exhibit may, all of those things are counted in my favor if I'm a 21-year-old. So it suits me to go to trial. Because the chances of, the longer it takes, the chances of things going wrong increase as well. So a rational thinking person wouldn't enter a plea at 21 years old for 15 years. So there's no incentive there. What other jurisdictions have done is that in the Cayman Islands, they have done is actually incentivize the process. So what they say is that notwithstanding the minimum, if you plead guilty, then this is the rate, which is significantly lower than the 15. But if you go through a trial, then now we're starting at 50. Then now a rational thinking person is going to say, well, this is something to give serious consideration to, but if it doesn't matter in the final analysis, then why are you going to enter a plea? Because the lawyer can simply say to you, or advisor, put the crown to proof. And all sorts of things can happen, and the lawyers here will tell you sometimes the exhibit can come into evidence for all sorts of reasons.